Is it working? Yeah, is it working? Yes. Yeah, great. Great. Thank you very much, Judge. Very powerful speech and a very good lesson. Again, feeling as a student. Thank you very much. So welcome, everyone. Good morning again. My name is Dimitrios. I'm one of the founders of the European Whistleblowing Institute, and I'm very happy to chair this panel. Wonderful ladies. I'm very happy to be among women. I love that. And very good weather, so maybe God is a whistleblower, who knows, but it's very nice to be in Brussels with 20 degrees. So in this first panel, we will talk about the state of whistleblowing at the European Union level. So we have the directive, we have transposing laws. So what is happening now is one of the major questions we are going to address. So the panelists, I feel stressed myself because I was reading some of them when I was writing my thesis. And what I have to say for the state of the whistleblowing is when I started writing my thesis, there was nothing at the EU level. So I was desperate to write about whistleblowing, so I said I will do a comparative study. And everyone was telling me there will be nothing at the EU level. Then in the middle of my thesis, the proposal was published. So all my thesis had to change. So just to say that, you know, these kind of changes, they can happen very suddenly, and we are very happy for that. So we have Georgiadou, who is the deputy head of the Unit for Fundamental Rights at the DG Justice at the European Commission. Also worked at the Court of Justice with President Skouris. Very welcomed. We have Zuzana Dlugošová. Correct? Great. She is the president of the Whistleblower Protection Office in Slovakia and also the vice chair of the Network of European Integrity and Whistleblowing Authorities. A very nice initiative. We will learn more. Lawyers with human rights ethics and work experience at the European Court of Human Rights. We have Anna-Kristiina Mikkonen. Good, great. Thank you. She's a member of the parliament in Finland and also in the Parliamentary Assembly of the Council of Europe, and a lot of work on whistleblowing. And Anna Myers, I think everyone, you know all of them, but Anna is quite known, more than 20 years. She is the president of the Whistleblowing International Network. She's a lawyer. She has written, advocated a lot about whistleblowing, having worked in Protect and also in Greco, the anti-corruption group. So the idea of this panel is to see where we stand, what's happening, and maybe what the future holds about whistleblowing. So not anymore from me. I will give the floor for the introductory statements. I will start with Zeta, and thank you very much.
Hello? Yes, perfect. So, as many of you know or may suspect, I am Greek. And as I'm sure you all know, we Greeks have this annoying tendency of referring in all kinds of situations to our illustrious ancestors and to ancient Greek concepts and ideas. So I cannot help but point out that whistleblowing stretches far back in time to the ancient Greek concept of parrhesia. I don't know if we can show it. It's behind me? Okay. So parrhesia literally means saying everything, speaking the whole truth. And it implies not only freedom of speech, but also the courage to speak the truth for the common good in the face of danger at personal risk. So it is about fearless speech. And in the Athenian democracy, parrhesia was a central moral and political value of speaking truth to power. Whistleblowing, the equivalent, the modern equivalent of parousia, is a key safeguard for the values of rule of law, fundamental rights, and democracy. And at this moment in time, where these values are under attack, as both speakers before me highlighted, it is important that all we who work for the protection of whistleblowers keep in mind that our everyday work is essential for the defense of our democratic values at every level, the local, the national, the international. The Whistleblowers Directive entered into force in October 2019. 5 years ago, basically, there was no comprehensive legislation at EU level. There were only some elements of whistleblower protection in some specific legal acts in specific policy sectors. Overall, whistleblower protection at EU level was fragmented and uneven across member states and across policy areas. Back in 2016, when there were the first calls for a horizontal EU legislation by the European Parliament, civil society, trade unions, academics, nobody in the Commission knew much about whistleblower protection. It was practically terra incognita. And it is thanks to the hard work, dedication, and perseverance of several politicians, public servants in national administrations, experts, academics, and other stakeholders, many of whom I see here today, and of a few faceless bureaucrats, that we have now in place state-of-the-art legal standards, which are the law in the whole European Union, but also lead the way for the accession candidates and can be a driving force for promoting high standards globally. In the six infringement procedures mentioned before, where the Commission referred Member States to the Court of Justice for lack of transposition of the directive, the Court upheld the Commission's actions, imposed financial penalties, as previously mentioned, and also highlighted that the directive is a crucial instrument of EU law, in that it lays down common minimum standards providing for a high level of balanced and effective protection of persons reporting breaches of EU law in areas in which such breaches are likely to be particularly harmful to the general interest. So this is the Court recognizing that we now have in place a powerful tool for the enforcement of EU law and for the protection of the general interest. This does not mean that we should now rest on our laurels. In the course of this conference, we will have ample opportunity to discuss any remaining gaps, outstanding issues to be addressed, or new challenges that have emerged. And speaking of emerging challenges and remaining gaps, I would like to draw your attention to the upcoming evaluation of the directive, to which we will need your contributions. We will be assessing different aspects of the functioning of the directive, its impact at national level, namely how successful the directive has been in achieving its objectives, whether its provisions are working as intended, how efficient it has been, whether there are any costs or burdens that can be alleviated and reduced, and to what extent it is still relevant and fit for purpose in view of current challenges and emerging needs. In this context, we will also assess whether and how Member States cooperate in case of reports on breaches that have a cross-border dimension, and we will also assess the need for additional measures, including possibly amendments, with a view to extend the scope of the directive to further EU areas or acts, in particular to the protection of the health and safety of workers and working conditions. This evaluation report will be published by end 2026, and based on its findings, the Commission will determine any future actions that may be taken. For instance, the evaluation could conclude that there is a need to review the directive, in which case we would need to carry out an impact assessment, analyze the different options, the impacts. Or the evaluation could also point to a need for flanking measures to support the effective implementation of the directive. For the purpose of this evaluation, we will carry out extensive consultations, including a public consultation and targeted consultations with all relevant stakeholders, national authorities, civil society, trade unions, business associations, judges associations, bar associations, academia, and international organizations. If all goes all well, this consultation should be launched towards the end of this year, and we will make sure to make wide publicity because we really count on your input. But before going into all the work that still needs to be done, I suggest that we do not lose sight of the huge progress already made and remember how far we have come. Thank you. It's yours.
Thank you, Zeta. We are waiting for that. So now we'll pass the floor to Zuzana for her introductory remarks.
Thank you very much, distinguished members of the panels and dear conference participants. I'm honored to be here today to share my thoughts with you. And first of all, let me send my big thanks to the organizers for giving us all this great opportunity to meet and talk, which is very important. I'll start with a short story. In 2021, in the very first days of the Whistleblower Protection Office in Slovakia operation, a whistleblower turned to us. He was a middle management employee in a state-owned company and reported internally about violation of public procurement law in maintenance services worth several million euros. So he decided to report internally after the change in management of this company, as he believed that the new managers will do something about it. And after the company denied any violations, he turned to us. He specifically said that he would wait until the office started its operation so that he could report the matter. So after the office's action, we prevented him from losing his job, his position, and there were really many attempts by this company to demote him, including taking away his bonuses and the company car. And if you ask me what was the outcome of the report, the criminal proceedings are still pending. So it has been 4 years now since I boarded the train of the institutional whistleblower protection. And since then, I experienced really many effective assistance to concrete whistleblowers, hundreds of hours of really good training for employees, be it in public institution or private institution. But I've also experienced serious delays in proceedings, specifically in criminal investigation, and first clash with political power that resulted in a financial sanction being imposed by our office to the Interior Ministry for violating the law. I also witnessed attempts to change the law to reduce the standard of protection, also threats by politicians to abolish the office or to prosecute its representatives. If I take into account the mixture of the positive and the negative, I would have one overall experience or a message, lesson learned to take away with me, which is that it really takes a village to make effective protection of whistleblowers a reality. a big step forward was institutionalizing protection, so starting with whistleblower protection institution, competent authorities. Many of you are sitting in this room, but it's far from just setting up institutions. It is also about support by political leaders, private managers, NGOs, also effective and impartial law enforcement authorities. Without that, it's pretty ineffective, I must say. And it's also about reflection by academic world and judicial decisions, so that the expectation for fair treatment of those that stand up for public interest become a standard. So, and after all, it's also about the general public, because it also needs to know the rights that the law provides to it. So it really takes a village. I think that whistleblowers are really essential in enforcing the law and returning us back to integrity of our actions. And it is of no coincidence that another organization, a European association I represent here today, is called the Network of European Integrity and Whistleblowing Authorities, starting back in with 2019 with 8 organizations, and now NEIWA includes 33 competent authorities for which the whistleblower protection plays a pivotal role. And I must say that the credit must go to the Dutch House of Whistleblowers that started this initiative back in 2019, and I greet my colleagues here sitting in this room. So what is the goal of NEIWA? Of course, we share experience among the members in a wide range of our activities, but we also have the ambition to send recommendation and to share experience with the outside world. Most recently, we have prepared a comparative study of 9 member states about the models, what they apply in following up on dealing with whistleblower reports. So this is something that we can share in a couple of days with the general public and the experts. And we also have established that, for example, psychological assistance for whistleblowers is a highly effective measure of support. And many whistleblowers say that in some moments it is more effective than the legal support. And we figured out that only really tiny part of our competent authorities across Europe really have such a service in option for potential whistleblowers. So with that final message, I think that we see that there is a lot of work to be done, and we see many, many loopholes in timely and effective whistleblower protection. But on a positive note, we have to admit that some 6 years ago, we wouldn't have imagined that states would dedicate so much institutional energy into whistleblowers and whistleblowing protection, which is very important. And in these fragile times that we live in, I think these kind of interactions and supportive meetings, we need to be happy about the possibility of interaction, and of course a lot of stands in front of us. I appreciate very much that I see in this room sitting so many villagers that can meet, talk, and inspire each other, and I look forward to further discussion today. Thank you very much.
Thank you, Zuzana. Excellent work to you and all the colleagues, all the authorities. So I will now go to Anna Myers for her introductory comments.
Do I have to do? I don't have to do anything. That's always good with technology and me. I'm absolutely delighted to be with you here today. I recognize so many faces in the room, but I also know I'm going to make new friends today. And this auspicious panel. Thank you, Vigilenza and the team at the European Whistleblowing Institute. We are all partners in this, and the more we work together, the more effective we'll be. I'm just going to start off with just some words, because, you know, it's nice to start with language. alertador, whistleblower, lanceur d'alerte, Glockenläuter, signalista. All of those words were coined by civil society. None of those words and phrases for whistleblowing came from institutions or governments or lawyers, although some of the civil society were in a legal frame of mind at the time. But these are all words that allow us to give a neutral and positive meaning to the idea of speaking up, speaking out, speaking truth to power. And I'd like to remind everybody in the room, and I think those who know about the Whistleblowing International Network, the group of civil society organizations that set it up, the Government Accountability Project, Tom Devine is here, one of the founding members, along with Protect, which at the time was called Public Concern at Work, FAIR in Canada, Whistleblowers Netzwerk in Germany, and ODAC, the Open Democracy and Advice Center in South Africa. It has never been an only European endeavor, it's been a global effort. These organizations were already working together in an ad hoc way, finding out about each other. We were being contacted by civil society around the world, new initiatives, often public interest lawyers who'd worked either in the field of consumer protection, human rights, transparency, and ultimately corruption. So I wanted to remind everybody that in a sense, this, and Judge Kulnerik phrased it perfectly, is a civil society effort, is all of our effort. It is in the public interest, and it is about accountability. It's not about whistleblowers, really, in a really odd sense, because it's about them showing us where our accountability mechanisms are failing, are not working. They're about all organizations, whether they're in the public or private sector, have a risk of something going wrong, and their decision-making affects all of us, whether we buy a car or we go to the local authority to register a company. So it has never occurred to me, and most of us who've worked in the field, that it was divided between public and private sector, that it was just about corruption, that it was about wrongdoing and holding power to account, and guess what? Whistleblowers also blow the whistle on NGOs and charities because they are organizations and can get it wrong. So I wanted to start off with those words, and then I'd also wanted to do just a quick view of laws. Now, Tom and I are completely in agreement in, and many lawyers in the room would say, if you just have the law, you're a bit screwed, because that's a backup mechanism. That is so important, and it does provide the institutional accountability, and it does provide your backup. But what whistleblowers need is support, and they need not to be the only messenger, because that ultimately puts them in an isolated and easily squashed position. So WIN sort of again comes out of this idea of sharing the space, reaching out, working with other partners, affiliated partners like EWI, like Transparency International, who's done so much work. And if you look at the laws, so again, although I'm saying that at the outset, and then I'm going to jump into the laws, it does show you a trajectory. So in 1989, we had the first whistleblower protection law in the federal government. Is that right? 1989 was the first one?
It updated in 1978.
A 1978 one. So we're going back a bit. We had one law, and that was a US law, and it came out of holding power to account and government accountability. We had 4 laws by 2000. By 2010, we had 12 laws. These are laws around the world dedicated, either in the public-private sector or both, to whistleblower protection. 2010, I said 12 laws. Well, in 1999, the Council of Europe Civil Law and Criminal Law Convention started to put whistleblowing in there. They used it as civil servants being allowed to report, and slowly got around to, oh yes, if you're allowed to report, then maybe you need some protection if there's somebody who's reacting negatively to your report. We had as well PACE Committee on Legal Affairs and Human Rights, so this is the Parliamentary Assembly at the Council of Europe, doing investigations, resolutions, recommendations, and starting to really put it on the map. Then we had, in 2019, the Congress of Local and Regional Authorities, the Protection of Whistleblowers report that Vigilanza Abbasi was the consultant on. But we also had, through that time, the Greco evaluations and recommendations, group of states against corruption, fitting in whistleblowing. I happen to have been around for some of those and making sure in some of those evaluations we were looking at whistleblowing at local authority level looking at how the judiciary was set up, how prosecutorial authorities, they've been doing a lot of work. And of course, we already heard about the European Court of Human Rights, which continues to play a key role. So we've got a legal framework, we've got jurisprudence, and we've got policy in Europe for a long time. 2020, 35 laws around the world. 2024, 62. And as far as I know, so we've had this kind of, a graph is great. I have a graph. It didn't make it into the PowerPoint. But I wanted to show you how, especially when we started to talk about corruption, there was a much more easily understood pickup of whistleblowing. And civil society was in the room on all of them. In 2020, whistleblowing, obviously we had the directive, we were very excited, and Win with some very trusted partners set up the EU Whistleblowing Monitor. And you're right, that little horse race we had going as a graph showing which member states had done anything was stalled. It was the longest horse race because even when they passed the deadline, there were still very few that had made it over any mark. And we did have some governments coming to us and saying, how can we show we've made any progress? We're like, well, what have you done? And they said, we've consulted. And I said, have you told anybody? Like, no. Well, we only put publicly accessible information on our website, so we won't know if you've done anything until you say it out loud. So we have been in this space. There's a lot of organization. There's a lot of people now. I'm meeting young lawyers who are doing theses, and they have a thesis. And I'm like, oh, you're deciding to work in whistleblowing. Most of us found ourselves in it because we understood it was important, and a lot of people didn't even understand what we were talking about. So we have now a whistleblower protection community. We have civil society, and I would count all of you in your own personal positions, but even within your institutions as being part of that community. I wanted to leave you with both my biggest concerns, the pioneering aspect of the EU directive, my biggest concerns, and my optimism. And it might be just because it's pathological. But for me, the big pioneering aspect of the EU directive is its focus on accountability. It is one of the first legal instruments to actually recognize that institutions had obligations. Because most of the laws before that were about protecting from interference, which meant that you had to suffer retaliation before you took a court case. Now there's an ability to hold institutions to account for failing to deal properly with whistleblowing. It's a start. It's an important start. It also recognizes that all institutions and organizations of all types need to be covered, and that actually it's about the public interest and not just about corruption. And it's fascinating that it's the EU that passed that. My biggest concerns are the number of governments who have taken a minimalist approach to transposition. There are some good practice examples and some are great, but the minimalist protections mean that there's a risk that it won't work. And the political winds have been changing, and we know what's happened in Slovakia. We know with the Hungarian government, even with the recommendation, things didn't really get started there on whistleblower protection. So we have challenges in Europe, and we have challenges with winds blowing across the Atlantic. So we need to be there because whistleblowing is going to only get more important. Whistleblowers are only going to be more at risk, and we do need to act as that community. My optimism is that you're all in this room, that we have an understanding of the issues at stake, that there is a recognizable, and I hope WIN has played a role, whistleblower protection community that see themselves as part of that community, and so we understand what's at stake and why we're here today to continue this conversation and support those who speak up. Thank you.
Thank you, Anna. And now, Anna-Kristiina, your floor is yours.
Thank you very much. It's a great honor and a pleasure to be here today. I'm pretty new on whistleblowing, but it's great to be here with the experts and give some impact to this panel. Last year, the Parliamentary Assembly appointed me as a rapporteur for a report entitled Ensuring Better Protection of Whistleblowers in Europe. And it is now being prepared within the Committee on Legal Affairs and Human Rights. As a background, you probably all know that the Parliamentary Assembly played a leading role in the development of European standards for the protection of whistleblowers. Back in 2010, the Parliamentary Assembly adopted a resolution and a recommendation which highlighted the challenges faced by whistleblowers and the striking lack of international standards to help protect them. At the time, the Parliamentary Assembly called on the Committee of Ministers to develop some guidelines for the protection of whistleblowers. This is, of course, what happened, as you can remember. The Committee of Ministers adopted a recommendation on whistleblower protection in 2014. And a follow-up resolution of 2015, the Parliamentary Assembly called on the European Union to adopt a directive on whistleblowing. And in 2019, the Assembly commented on the existing drafts of the directive and encouraged its enactment, which of course it was later that year. The European Court of Human Rights has also developed a rich case law on whistleblower protection, in particular under the right to freedom of expression, referring to the Assembly resolution and the recommendations of the Committee of Ministers. I do not recall this history to claim credit on behalf of the Assembly for the development of these international standards. Many people were responsible for helping to bring about the recommendation and directive, and notably it was pushed forward by the hard work of many of the individuals who are here today. I recall these developments to put the current work of the Assembly in its context. The report that I'm working on is designed to follow up the earlier work that the Assembly has been doing to see how the international standards created by the Council of Europe are being implemented. In particular, I will analyze current national frameworks, identify remaining gaps, and make some concrete recommendations for improvements in particular states, in order to encourage them to bring themselves into line with the Council of Europe recommendations and the EU directive. An introductory memorandum has already been done, setting out the future work to be done on the report. This document is public and it's available on the website of the Committee of Legal Affairs and Human Rights, if you are interested. The report will not seek to survey all the 46 states of the Council of Europe, but I will instead aim to highlight a selection of states where shortcomings in national frameworks have been reported. Countries which are not on my radar are naturally the 6 EU states, which have been referred by the European Commission to the European Court of Justice for failing to transpose the directive. And these 6 lands are Czechia, Germany, Estonia, Luxembourg, Hungary and Poland. Outside the EU, I have received reports of concerns about a number of states, including Iceland and Serbia. However, I want to emphasize that this is very much a preliminary list. My aim would be to gather as much as information as I can about any state where reputable stakeholders can demonstrate the framework is not meeting the European standards. The Parliamentary Assembly has a long tradition of engaging the national governments, academics, civil society, national human rights institutions, and others who provide the information which is essential to the Assembly's work. I want to continue that tradition and talk with you here, as many of you as possible. In terms of timeline, I aim to finalize the report by the beginning of 26. A final word on the content of the report. As I have outlined, the main focus will be on identifying how states are complying with the existing international standards, the Council of Europe recommendations, and the European Union directive. I know that many stakeholders make the case that these standards need to be updated, improved, and replaced. I am aware that the European Committee on Legal Cooperation is considering suggesting ways in which the Council of Europe recommendation and whistleblowing can be updated. And of course, I'm open to also consider this issue and perhaps include some recommendations in my report about changes to the Council of Europe standards, whilst noting that that the main focus will remain on compliance with the existing standards. I look very much forward to participating in the discussions today. Thank you.
Thank you very much. So much reading for us, actually. Okay, that's good. So now the good part, my questions, and then and then the questions from the public, from all of you at the end. So I will start with Zeta, and I will say that we have the directive. What are the initiatives of the Commission now? What is happening that maybe we don't know and you can say to us? And a point is about culture, because I think there is a lot to be done in this field. So if you can guide us through the actions. Thank you.
Thank you. I think about our current work already Mrs. Kolnerik referred to the transposition report. And indeed, beyond some ongoing infringement cases we have open still for incomplete transposition, we have now started having extensive exchanges with member states to seek clarifications on non-conformity issues that we have identified and, where necessary, to invite them to amend their legislation. But again, as you just mentioned, laying down in law high protection standards, it's just a first step in a long journey, because even the most sophisticated protection regime can only be fully effective if it is supported by an overall enabling environment that can create this famous speak-up culture in the private and the public sector. So going beyond the application of the legal standards of the directive, we are trying to build this overall favorable ecosystem for whistleblowing. And of course, a key element of this ecosystem is awareness. Awareness-raising measures are necessary to increase the public's knowledge about reporting channels, the availability of protection, but even further than that, to create and encourage a positive perception of whistleblowers as persons who act for the public good and out of loyalty to their organization and to society in general. Another key element is building capacity and knowledge of all relevant stakeholders, including private employers who are also the primary enforcers of whistleblower protection, public authorities, including the authorities entrusted with receiving reports, law enforcement, justice professionals and judges, and of course civil society. And for this there is particularly training and guidance tailored to the specific needs that needs to be developed. Also essential to promote sharing of experiences and the development of guidance and exchange of good practices, in particular by national authorities, as happens in the case of NEIWA, but also civil society organizations working on the front lines. Last but not least, we see a need for all stakeholders to join efforts. It's essential to promote cooperation between national authorities, including across national borders, but also between national authorities, business associations, and civil society. So we are encouraging member states to take such actions. We promote relevant initiatives in the exchanges we have in the expert group on the transposition of the directive, and we are also promoting the use of the technical support instrument to help improve administrative capacity, processes, and infrastructure. We also offer financial support to capacity building, awareness raising, advocacy, analytical activities under the Citizens' Equality Rights and Values Program, the Justice Program, and the Internal Security Fund. And this bright project is a bright and shining example of the kind of actions we aim to support. Beyond the work to maximize the effectiveness of the directive on the ground, another work stream we are pursuing is to enhance the contribution of whistleblowing in the fight against corruption. Whistleblower protection is now embedded as a key part of the rule of law toolbox. And in the context of the fight against corruption, the annual rule of law reports present developments and emerging issues regarding whistleblowing in member states and certain enlargement countries. We are also supporting the efforts of EU candidate countries to align their institutional and legislative frameworks with EU standards by providing advice and technical expertise in the screening process, but also in the discussions of our expert group. And as an illustration of the political momentum, next Tuesday, 8th of April, whistleblowing will be on the agenda of the EU Western Balkans Senior Official Meeting, and again in October in the context of the annual ministerial meeting. Likewise, we also promote higher whistleblowing standards across the lines of the EU standards in partnership agreements, for example, with Armenia. Finally, I would like to refer briefly to our work to promote the directive as standard setting globally. For instance, we cooperate with the UN Office on Drugs and Crime in the context of the UN Convention Against Corruption for the implementation of the 2023 resolution on protection of whistleblowers. And in particular, we're working together with them and with the civil society organization here present to present a study, an international study on whistleblower protection, the preliminary findings of which will be presented in June in Vienna. But I think I will stop here and maybe give more details later. Thank you.
Thank you very much. Thank you. So now I will go to Zuzana. And because we didn't have authority, I mean, we had some authorities on whistleblowing before. So is the directive this game changer? Okay, and then my concern is, are these authorities independent and autonomous, like the directive desires?
Thank you for this difficult question. It is definitely, in my opinion, a game changer to the extent that it really promotes establishment of authorities. I will keep it simple. Authorities that coordinate certain roles, and the directive is not really that concrete what kind of powers and competencies they must have. And I wonder, Zeta could tell us, whether the directive really requires from those whistleblowing competent authorities to be independent, in a sense, independent and autonomous from the executive power. In my opinion, a higher level of independence and a certain level of autonomy from executive power definitely helps to act independently even in more sensitive cases. And we know that these are actually the most important ones. The more is at stake, the most important is that there is a reliable channel, reliable institution that the whistleblowers can turn to, and of course the more competencies to protect, even preventively or after the damage was done effectively to whistleblowers is a positive sign. The directive sets the minimum standard, I would say, in that sense, and we see across the European space that there are really different powers and competencies of competent authorities. And even in NEIWA, we see that those typically those authorities that are under the executive powers has less competencies and powers, less freedom to say. I'm not going into details because we see so many differences among us, and this is not critical. We shouldn't let the perfect be the enemy of the good, as we say. That of course we should be happy about any progress, and this is, to your first question, this is definitely a progress, and directive help that process, but I don't know whether the legislator went that far that they had a concrete image of having established independent authorities across Europe. I can speak on behalf of our authority, of course, and I am in touch with others, and there are many positive aspects to being more independent.
Thank you. I'll come back to that maybe. So now we go to Anna. So, I mean, you're very long in the area of civil society, NGO. Just to say now with the directive, do we see more civil society? And given, because we'll talk about it, this current political situation, does the government love civil society and whistleblowing?
Yeah, well, I would say, first of all, yes, there is a lot more engagement, certainly in Europe. And again, it's been a longer conversation in Europe. Certainly around the directive, even the adoption of it, I think for the first time did I really see a coming together of what I would call across professional, quote-unquote, borders within the nonprofit world. So the protection of journalists organizations, the trade unions were incredibly important in creating the platform that we were all part of to push for the EU directive. And that was the first time I'd really seen it be natural that we all came together and we all worked together so well, because we knew we had different missions and we had different perspectives. So we had primary goals or red lines that developed with the responses and as the EU was being discussed and negotiated. And so we came together on that. And I thought it was amazing between Eurocad, TIEU, WIN, Tom Devine at GAP. We did a lot of work around explaining legal provisions, the necessity for them, but in plain English to anyone who would understand it. And I think that's the thing about whistleblowing. I was talking to Kate Kenny last night. It's always seemed incredibly simple concept to me, which is where I get baffled by everyone going, it's very complicated. It's people who see something going wrong and they report it to someone who can do something about it. Most people in a workplace are not the ones that can address everything and resolve the problems. Then you have regulatory authorities that have powers to regulate a sector. They rely on information from everyone, citizens, including why shouldn't those inside organizations be able to go to those authorities? In fact, that is the sphere of accountability. Again, this is all about accountability. And of course, ultimately, the public holds the governments and the institutions to account. So it fits within the human rights freedom, public access to information, freedom of expression. It's the response that complicates whistleblowing. It is the attempt to control information, which again, I completely understand organizations operate with understanding their information, but I think they also, and I sort of describe it as this is such a North American, I'm Canadian, by the way, if you're confused with my accent. It's not maybe as obvious as the Greek, the Greek identity, but we are a very independent nation. Just saying, yes. But to me, it's a little bit the arrow over your left ear, you know, reminding you that you have to look and you have to be aware, and it sort of whistles by. And so it's not comfortable for organizations to deal with whistleblowing. So I think in Europe, there's been an incredible sort of lead. I see a lot of people in the room who've taken these issues forward in their countries, from Hungary to Romania to Slovakia. These people are in the room, and there are civil society organizations pushing this, and they've been very, very active. So yes, there are more. But would I say globally, and even with Europe, the kind of specialized understanding, the real understanding of how, even if you are a lawyer, this is about public interest lawyering. This is about supporting someone getting the information to the right place, maximizing the opportunity that it will be addressed, because that's where we're in complete agreement with most of the institutions. We want the issues addressed. We want the harm to be prevented or stopped. And yes, ultimately, those responsible for making bad decisions to be held to account or accountable. Doesn't always mean jail. But if they need to go to jail, we want the impunity not to stop at some sort of gate of an organization. So to me, I think that is where WIN and these meetings is really important, to build the capacity to really understand how to best advise whistleblowers, to give them, because you're right, legal advice has to be within this broader understanding of how do we address the public interest and minimize the risk to individuals. So yes, I would say it's growing. Organizations and networking and trusted partners is absolutely essential. We can share that knowledge, and we don't all have to be experts on all of it. And that's what the communities are so important for, and why WIN continues to just facilitate. Well, if you've got this issue, I know the expert you should talk to, and this person's over there, because there can't be one place. This is really important that it is a shared responsibility, and that information is actually dispersed, you know, that it gets to the right people at the right time. So yes, but there are challenges. And one more aspect of civil society is I feel it very, very strongly now that we need to be in communities of support, because we know that where organizations or those who are committing wrongdoing or really do not want to have their decision-making out there in the public domain, they'll go after the most weak point. So they will go after the whistleblower when they can't go after the journalist. They will go after the civil society organization when they can't go after the whistleblower. They will go after the union rep when they can't go after the whistleblower. They will go after the whistleblower if they can get at the whistleblower. And sometimes they go after the other ones to get to the whistleblower. So you see court cases with journalists and the whistleblower there, or trying to get the journalists to give up their source. That happens now to the authorities as well. So this is really important that we're in partnership so we can support each other's existence. And there's more of us. So we create a bigger protection, really, for the whistleblower and for ourselves.
Great, perfect, that's perfect. So Anna-Kristiina, Council of Europe, you know, it was the pioneer before the European Union. So where do you see now the Council of Europe? Because you're working, do you see a more directive approach or more court approach? Or if you can say, of course.
That was a good question. You pointed out that we used to be pioneers. Yeah, I hope that someday again we will be pioneers in some some questions, but of course now the development of the protection of whistleblowers is in the European Union level, and of course the Parliamentary Assembly is trying to do some developments how to improve better protection and the measures, but all we can do is to make resolutions, recommendations, and we have good EU standards at the moment, which have been done by the recommendations of Council of Europe. But if the states are not implementing the existing EU standards, so what can we do? We can say that, hey, you need to do that. And they are just like, we are not doing that. So what is the punishment of not doing that? But yeah, there is punishment also. But the role of Council of Europe is more like recommend improvements to the existing standards, and then also how to improve the development of the member states and so on. So I would say we have a role, but it's we are now a little bit in the curtains. Yeah.
Just to clarify, no, I mean, you're still a pioneer, you know. Just a very quick question to that. Do you see the non-EU member states trying to follow your recommendations, or also the European Union, or you see them, what's your perception for the non-EU member states of the Council?
I hope that especially the ones who are trying to be member states of the EU will follow up, of course, and they need to follow up the recommendations of the European Council and EU. But then, of course, if you think about whistleblowing as a general question, we need to have global standards how to protect the whistleblowers, because it's a global question. So we need all the states to be involved within protection, and the role of civil society is very much indeed important in this question also.
Thank you. I'll come back. So I'll go back to Zeta and ask if you can tell us, so what's the future now? Where the state is here, we are here, so what's the future now?
I will look into my crystal ball, but before that, I would like, first of all, to highlight the important role of both civil society and the Council of Europe. Civil society, I mean, Anna, if you were baffled how come people don't understand whistleblowing, you should have seen the generalized bafflement of the whole Commission on what the EU can do back in 2016, and it's thanks to some people around here who explained to us in simple terms that the directive was drafted. And also the Council of Europe. We were very heavily inspired by the Council of Europe recommendation. We drew on every single principle of the recommendation. A careful reader will even find some wording reflected in the recitals and the articles of the directive. And on many issues, it allowed us to go further than the Court of Human Rights, like the absence of good faith, and also all the issues like the broad personal scope, the principles when it comes to the interaction with national security, and so on. So I would even count on the Council of Europe supporting further progress in standards in the EU and globally. And coming now to your question, well, I know that many people ask about the future of the directive specifically. Well, this will depend, what will be decisive will be the outcome of the evaluation. if it is concluded that there are new challenges or blind spots, outstanding gaps that need to be addressed, and if so, whether it is necessary to amend, extend, strengthen the existing rules. For the rest, as you may have seen in the political guidelines of the present Commission, in the mandate there is a renewed impetus for the effective enforcement of EU law, the strengthened protection against, of the financial interests of the Union, a strengthened fight against corruption, and for promoting accountability and transparency at the level of EU institutions. Many recent developments point to the urgency of effectively addressing all these challenges, enhancing the integrity both in public and private sector, and increasing trust in democratic institutions, both in the EU and beyond. So, although I cannot right now announce concrete actions, I can tell you that we are looking into ways of better leveraging whistleblowing so as to effectively address all these priorities. And of course, that any views or insights you can share with us based on your experience and expertise will be most welcome to feed into our reflection and our future actions.
Great, we will do. So now, Zuzana, back to you. I believe the network is important, correct, as an initiative?
Definitely.
Do you see maybe the need of a European office on whistleblowing?
I don't really have reflected on that question at all. I think we are still in the phase of kind of analyzing and knowing the environment, and also, as Zeta said, even we didn't finish the circle of having the evaluation of all the legislation and practices. And we also in NEIWA community, we are coming to the real point of our everyday practice. What is the good practices? What sorts of proceedings are they? What are the gaps in effective whistleblower protection? And I must say that the national security buzzword starts to be a very, very handy excuse for powerful people and governments to avoid whistleblower protection in general. So this is something that we are coming to. So we are kind of deeply dived into these kind of practicalities, I think, which is a very useful process for all of the stakeholders sitting also in this room. And I think there can be a moment where we would probably reflect upon some kind of European standardized process. We know that there are also cases in some countries that reflect on whether a simple letter to any European institution might be deemed as a whistleblowing report. So that might be maybe moments when we need to fix some regulation in order to remove certain inaccuracies or maybe uncertainties in interpretation of the law. Once we can overcome this kind of formalistic approach and see that, okay, the content is important and not the institution to which the respective person turned to, then probably we wouldn't come to that. So it depends, and we will see. I think let us do what we can for the time being, and then let us reflect later on, I would say.
Great, thank you. Anna, my question is, do we want to see protection for civil society in the directive? To be recognized as, enablers?
Well, I think there's already a part of the EU directive that starts to talk about facilitating disclosures. Obviously, that was limited to within the workplace, but France has said that it's legal persons as well as individual persons. So that does give unions and other those who advise individuals protection. I think yes, but I don't know. See, I think when I first started being asked many, many years ago to talk about whistleblowing in countries where really there was no, and again, we're experiencing this more clearly ourselves, but really no trust in institutions. So one of the first trips I took as a young legal aid officer at Protect, a public concern at work, was to Nigeria. And what I saw was an attempt to put all of democratic accountability into a whistleblowing law. So I think what we need to do is really take a deep breath. We need to use the fact that whistleblowing does have this effect of everyone talking about accountability and trust and work out our gaps, but also hold, though, there are rules and regulations that need to be followed, and we need to be using this platform to really push that. We need to be thinking, I think now, about not just defending democracy, but how do we reimagine it? And I think whistleblowers do have a lot of, you know, they are experts usually. No one, very few people, and certainly governments, I think, haven't even gotten around to some of them, to understanding that whistleblowers have the answers. They're not just the reporters of the harm. They're often experts. They're often, some of the key whistleblowers have been very senior people who know what's going on and know how to fix it. Sometimes they'll say that system doesn't work and we need to replace it. So we should be really thinking much more progressively about what we're trying to achieve, because it is about action that builds trust. You know, yes, people will say that the biggest thing that whistleblowers or people will report is worry about fear of retaliation. I think that is usually put first when they're pretty convinced nothing will happen. And that actually, if they thought something will happen, and by God, we've all dealt with whistleblowers where we've gone, why have you walked into a burning building, you know, and because they believe they're going to make a difference. So I don't think we're going to stop whistleblowers coming forward, but I don't think we need to really think about what the gaps are and why. I think you're right not to go immediately to an EU office. We could create layers of more bureaucracy. We really have to make what's here work or rethink what's working, but use the whistleblowing platform to really pinpoint that. Can I just give one little thing? I was thinking of the 3 areas that the Council of Europe report could really report. So I do think, and they did this from the beginning, but guess what? It keeps coming back. National security, because that is somewhat covered by the EU directive in ways that governments, again, want to say it isn't. But the public disclosure part, which is the European Court of Human Rights, so that should remain strong. That's not as strong or as clear for member states in the EU directive. And then this issue around the duties, institutional accountability. So where are those big gaps? And one of the issues is a duty of care out of Australia, but again, whether that's been taken up as much as it should, that there's a duty of care so that those organizations who don't have systems, or you can show they're really bad, will be in trouble whether or not there's a whistleblower involved. So I think those 3 areas the Council of Europe has a really good run on, and they've already been there, but they're still there. And you saying that, Zuzana, about it's the catch-all. I remember being at an open government forum in 2016 in the UK when everyone was going mad about Snowden disclosures, talking about the mass surveillance program, this thing that was happening without anybody knowing about it, and my South African friends and my African friends going, so when did you wake up and smell the coffee? So this is not an unknown issue. This can be used for economic interests, all sorts of things, and they say it's national security, and they just pull everything out. Yeah, so that's, sorry,
Great.
I'll stop.
Negotiations happening. So we have 15 minutes for questions, and the floor is yours. So if you want, raise your hand and present yourself and address the